Cameron and Sorenlaw here today. We're going to be talking about Department of Homeland Security versus Regents of the University of California. Probably the most impactful decision, at least in a practical sense, the Supreme Court decided this past term. Now, to begin, we have to go back to 2012 when the Department of Homeland Security announced a new immigration program known as the Deferred Action for Childhood Arrivals, also known as DACA. That program allowed certain individuals to apply for a 2-year forbearance of removal. Essentially, you're not going to get deported. It also granted such relief as eligible work authorizations and certain federal benefits. Approximately 700,000 individuals were able to avail themselves of this program. Now, there are certain requirements that were put in as part of this DACA program. Things like individuals would not be eligible if they had committed any serious crimes, that they'd been here continuously since 2007, that they had graduated high school or honorably discharged. Essentially, they were looking for productive members, productive contributors to our society, and that knew this country to be their home, their sole home. And then the Department of Homeland Security also issued certain instructions based on this program to ICE, the Immigration Customs Enforcement, along with other agencies in order to carry this one out. Then in November of 2014, DHS issued a memorandum that expanded DACA's eligibility by, among others, removing the age cap. In the same memorandum, DHS created a new related program known as the Deferred Action for Parents of Americans and Lawful Permanent Residents, and that's a mouthful, so we call it DAPA. Now, that program would have authorized deferred action for around 4.3 million parents whose children were either U.S. citizens or otherwise had lawful permanent status, residency status. These parents would enjoy the same forbearance, work eligibility, and other benefits as DACA recipients. Before the memorandum could be implemented, Texas, along with 25 other states, filed suit. The states contended that the DACA expansion and that DAPA violated the Administrative Procedures Act notice and comment requirement. We'll get to that in a second. Also, the Immigration and Nationality Act, commonly known as INA, and then the executive's duty under the Take Care Clause of the Constitution. That third one, typically a winning argument. Real good one. All right, so the district court ultimately entered a nationwide preliminary injunction finding the states were likely to prevail. It was then appealed to the Fifth Circuit. The Fifth Circuit, in a divided panel, ultimately upheld the preliminary injunction. Now, the first question the Fifth Circuit had was, is this, as the government contends, an unreviewable agency action just related to enforcement? The majority of that particular panel rejected that argument emphatically. That it was far more than non-enforcement. It affirmatively conferred lawful presence and associated benefits on a class of individuals who just a little bit before were technically here illegally. That was a little bit more than agency discretionary enforcement. The majority then upheld the injunction on 2 grounds. And it wasn't the executive duty under the Take Care Clause, in case you're wondering about how this story is going to go. So the first one was that the states were likely to succeed on their procedural claim that the DAPA memorandum was a substantive rule and required to undergo notice and comment. So essentially, agencies are given a little bit of room to work with when it comes to whether they elect to enforce or not enforce certain items. But when they rise to the level of actually creating a substantive rule, then they have to go through these notice and comment procedures as required by the Administrative Procedures Act. Well, in this instance, they definitely did not do any of the notice and comment, and according to the majority, this was a substantive rule. It then also held that the DAPA memorandum likely conflicted with the INA, which had expressly set out certain legal designations, defining classes, and what benefits each one of them were to receive. And this one sort of tossed that to the side. So this Fifth Circuit decision, of course, was then appealed to the Supreme Court. The Supreme Court did not have Justice Scalia and only had 8 members. In a per curiam decision, they simply said, it's a 4-4 split, that's it. So the injunction was left in place, and the case was remanded back down to the district court for further proceedings. Then, in June of 2017, following certain changes in presidential administrations, DHS rescinded the DAPA memorandum. And 3 months later, Attorney General Jeff Sessions sent a letter to the then acting Secretary of Homeland Security advising that DHS should rescind DACA as well. So the then acting Secretary of Homeland Security, Duke, acting on the Attorney General's advice, put together a memorandum, summarized the history of the DACA programs, the Fifth Circuit opinion, and said, well, the DACA program is likely illegal, so it should be terminated. Then she went through a brief description on how it would be wound down. Essentially, no applicants would be accepted, but they'd entertain applications for 2-year renewals that would expire, set to expire within 6 months. And then for everybody else, well, I guess you're out of luck. Okay, so that's what led up to this case. Essentially, we've got a memorandum that says, hey, we think it's likely illegal, so we're just rescinding it. A lot of individuals, including, among civil rights groups, even Microsoft, filed suit alleging that this action by the administration was illegal and violated the Administrative Procedure Act, among others. So, you get to oral argument before the United States Supreme Court back in November, I believe. And really the issue before the Supreme Court wasn't whether the Trump administration had the power to end DAPA, had the power to end DACA, because everyone agrees that it does. Instead, the question was whether the administration went about it the right way with regard to terminating DACA. Now, the big time decision comes out. Chief Justice John Roberts, writing for the majority, joined by the, I guess you could say, 4 traditional liberal justices, agreed that the decision to terminate DACA violated the Administrative Procedures Act. Essentially, they went about it the wrong way. Before they could reach the key issue in the case, they did have to address that question back from the Fifth Circuit had to elect on, which is this a reviewable action by an agency? Chief Justice John Roberts almost seemed to echo that Fifth Circuit opinion by saying this is not a passive non-enforcement policy. This is a program for conferring affirmative immigration relief. The creation of that program and its rescission is an action that provides for the court's review. You kind of get a sense that that argument probably went back and forth a few times when they had the DAPA injunction before them in court's chambers. So then Roberts, in this majority opinion, turns to the central question whether the Trump administration followed the proper procedures in terminating DACA. Now, under the Administrative Procedures Act, courts should not substitute their own judgment for that of the agency. Instead, the court's job is just to determine whether or not the agency made that decision based on consideration of the relevant factors and whether there's been a clear error of judgment. And in Roberts' view, joined with the other 4 liberal justices, the Trump administration had failed to meet that relatively low bar. Now, the first step in the court's inquiry, according to Roberts' opinion, is where to look for the agency's explanation. And he focused on the memorandum that acting DHS Secretary Elaine Duke provided when she announced the decision to terminate DACA in September of 2017. Roberts declined to consider a later memorandum that was issued in June 2018 by then DHS Secretary Nielsen, reasoning that it's, how did he phrase it, a foundational principle of administrative law, that courts should only look to the grounds upon which an agency originally rested. So, since Nielsen, in her memorandum opinion, referenced and expressly cited and relied on the one that was done by DHS Secretary Duke, well, basic rule here is clear. An agency has to defend all actions based on the reasons it gave when it acted. You can't suddenly come along later and say, oh yeah, it has these additional reasons once you start potentially coming under more fire. Roberts then moved into, shall we dare say, the second step of the court's inquiry. Essentially what the court is looking for as part of the second step is whether the agency really did in fact consider all of the relevant factors. Roberts ultimately found this completely wanting from the Duke memorandum. As he explained, the problem in the memorandum is that it did not consider the policy, at least in Roberts' view, was at the heart of DACA, the protection from deportation that the program provides. So, even if the benefits provided by DACA were illegal, Roberts noted, Duke still could have retained the protection from deportation. But instead, without any explanation whatsoever, she just said it had to be terminated as well. So what Roberts is getting at here is that DACA ultimately did two things. One, it said, okay, you're protected from deportation. You don't have to worry about that. You can consider yourself safe, if you will, if you become eligible for this program. But then there's the second element of various different benefits conferred on these individuals as well. What Roberts is getting at here is, yeah, okay, definitely there's some merit to suggesting that the benefits conferred under this memorandum, this action, could be illegal. Potentially even could be illegal under the INA. I'm just reading subtext here. But the protection from deportation, what exactly is illegal about that? I could be reading too much into this particular section of Roberts' opinion, but I think it's worth considering. And so he moves on and says, hey, you didn't consider that. You didn't also consider more accommodating termination dates, particularly with regards to the deportation aspect. So all of this really just says, I'm finding this wanting. Now, many of the challengers raised the argument that the Trump administration's decision to end DACA violated the Constitution because it was motivated with an intent to discriminate. The majority, sans Sonia Sotomayor, ultimately rejected that claim. So Roberts, in his majority opinion, sort of goes through and explains that although DACA recipients are overwhelmingly Latino, one would expect them to make up the outsized share of the recipients on any broad immigration relief because they comprise a large portion of the country's undocumented immigrant population. So virtually any challenge to a generally applicable immigration policy, if we accept the challenger's argument, seemingly at face value, would be an intent to discriminate. And Roberts is not willing to quite entertain that. Second, Roberts goes on and continues, there's not really anything irregular about the history of the decision to end the program. And then finally, he'll take a look at the statements by Trump that sort of were intended to show that he intended to discriminate, and Roberts opined into the majority opinion he found them unilluminating because the key actors in the decision to end DACA was Duke, then acting DH Secretary, and the Attorney General. In the closing, Roberts goes through and makes clear the court is not deciding whether DACA or its rescission are sound policies. It's only whether the agency complied with the procedural requirements and provide a reasoned explanation for its actions. The majority's view, it didn't. And the solution is for the court to send the issue back to the Department of Homeland Security for it to consider, and if it wants to resend the program again, for it to offer, shall we dare say, a better explanation. I would highly recommend they do so if they want this to survive again, because Roberts was particularly withering toward the end of his opinion. Now, Justice Sotomayor joined most of Roberts' opinion, except for that last little section on whether there was demonstrated intent to discriminate. Sotomayor's view, although, I can see some of Roberts' points, Roberts' opinion ultimately brushes aside statements made by the president describing Mexican immigrants in less than colorful terms. Criminals, drug dealers, rapists, things of that nature. And that this was, legal immigration was a keystone of Trump's campaign, and that taken together, she believes that that would be sufficient enough to demonstrate an intent to discriminate. Now, that's specifically what she was addressing in her concurrence. Then Justice Thomas wrote a dissent that was joined by Justice Alito and Justice Gorsuch. Now, in his view, in going through the history of the DACA program, the Trump administration rescinded DACA basically in the same way that the Obama administration created it, unilaterally and with just a single memorandum. And so it's not really clear in Thomas's view why a greater explanation than was ultimately put together by the agency was required in this situation in order to rescind it, given the explanation from the original one that created it. So, then we've got a dissenting opinion by Justice Kavanaugh. Now, Kavanaugh's dissent here is very tightly aimed. Essentially what he says is, I kind of get where the majority is coming from. But, in my view, when considering the agency's decision and considering the stated rationale, the majority should have considered both the 2017 Duke Memorandum and the later 2018 Nielsen Memorandum, which expressly addressed the extent to which the individuals, that DACA recipients had relied on the program, among other factors. Now, in Kavanaugh's view, the only practical consequence of the majority's decision is just to send the dispute back to DHS and just cause some delay. And he's not really clear as to why you could not also rely on that Nielsen memorandum. So this entire decision just seems to cause some sort of delay, and it's not really clear to him why the Nielsen memorandum would not apply. But for the meantime, DACA is unrescinded. It's back and forth. But it'll now go back to DHS, and now we have to see whether or not they'll come up with a better stated rationale. Now keep in mind, as I stated at the outset, there was no contention really by any of the litigants as to whether the Trump administration has the power to rescind these types of programs. The only question is whether or not they're going to follow the proper procedures. And that's something to look forward to. As always, I hope you enjoyed this and found it informative.